litigation. Is that a distinction that you were making, or am I reading too much into that?
I think what I would say is that the starting point is government doesn't weigh privilege. It's exceptionally rare. It looks at the particular circumstances and context of when the issue is raised. It obviously looks at the particular circumstance and context, and it has to weigh up the range of public interest factors. And as I said earlier, I'm very keen not in anything I say to be thought to be preempting the process government is undergoing, of looking again at whether it, at how that balance should be struck. There are a particular set of issues that arise in relation to litigation, and I mentioned this, I think, when I appeared in September, because the nature of litigation is that the government's previous legal position inevitably comes under scrutiny. An issue is being raised as to whether the government got the law right previously. Inevitably, that may involve the government having to reconsider whether it was right in the approach it took. It may, as I described in relation to the interpretation of paragraph 10, it may have to recognise that there's a serious argument to be had that it didn't appreciate that it needed to have. And the nature of advice in the context of litigation is an assessment of risks and uncertainties, the taking of advice, which of course is ultimately, it's advice. The only certainty is the certainty that the court gives you at the end of the day if the case runs that far. And there are judgments to be made both in terms of assessing the merits of particular arguments, and there are judgments to be made about the consequences of that assessment for how one should conduct the litigation. Litigation is a highly dynamic, by its nature, uncertain process, heavily informed by the legal considerations, and one in which it's particularly, it may be thought to be particularly important, government can take views candidly, that alternative views can be expressed candidly, that a debate can be had about what the correct judgment is, and what, as a result, what position the government should take in the litigation. So there is a particular focus in litigation, which is maybe thought to be relevant to the public interest considerations. But as I say, I'm very keen, I wouldn't want the committee to think that that is in any sense preempting or prejudging the way the government will approach the issue, which it's looking at again at this stage.
Thank you, Convener.
Jackie Baillie.
Thank you very much, Convener, and good morning, Lord Advocate. It still is just about the morning. I have a number of questions, so I'm very content with short answers, and I will try and be as quick as I can. Firstly, can I ask you, we obviously understand the process outlined by the Deputy First Minister in following the parliamentary vote, but can I ask you, have you received a request from the Deputy First Minister, or indeed from anybody in the Cabinet, in relation to the release of legal advice following the vote in Parliament?
I don't think it would be right for me to either preempt or
I'm not asking you to do that. It's a process question, and I was very clear that I can't ask you about the content, and I absolutely will abide by that. But it's the process, and I'm keen to understand in the process, have you yet been contacted by the Deputy First Minister?
Again, I don't think it'd be right for me to discuss what is an ongoing process that government's engaged in, and which ultimately will result in a collective decision by ministers.
Sure, but it's not the collective decision by ministers that I'm asking about. That's very clear in the Ministerial Code, but they do need to consult you, not as a minister, but in your role as Lord Advocate. I am merely asking a process question about, have they actually consulted you yet? Have they, picked up the phone, dropped you an email, chapped the door, gone on Zoom, anything? Have they been in touch with you about this?
Well, you say I'm consulted as Lord Advocate, the law officers required to be consulted. They are being consulted in their capacity as the government's principal legal advisors in the context of that process. So I'd want to, I don't think it'd be right to get into the way in which that process is being taken forward at the moment. The Deputy First Minister set out what the government is doing.
Indeed, and you referred to the process, which is why I'm asking the question.
Oh, yeah.
In terms of the I'm not asking you for the content, I'm not asking you for the deliberations. I'm simply asking you, has anybody contacted you about this yet?
Well, I mean, I'm clearly aware of the process that's
that wasn't
ongoing.
my question. I know you're aware of it because you're a smart man. My question is very specific. Has anybody contacted you yet?
Indeed, and I don't think it would be consistent with the collective nature of the decision-making process for me to, at this stage, when it's an ongoing process, to get into the ins and outs of internal discussions.
I'm not asking you to get into the ins and outs, but I accept, I've tried several times with you, Lord Advocate, to get an answer, so I'm not going to pursue that further. But I wasn't asking for the ins and outs. I was asking for one very specific thing. Okay, can I take us to the process of the commission of documents, because I'm interested in that. You told us previously that information emerged in, I think it was late December 2018, which made the government's case impossible to sustain. What exactly was that information that you were referring to?
What happened in the, and I'm not, I'm not sure if I used quite that phrase, but in any event, what happened in the commission was the production of two documents. And I think the committee has those as JR 011 and JR 017. Those documents disclosed additional contact between the investigating officer and the complainants, which had not previously been appreciated. The letter, the JR 011, was a letter which referred to a meeting between the investigating officer and the complainer, one of the complainers, on the previous day, in effect immediately before the formal complaint was made. And the other was an email chain which indicated arrangements to meet between the investigating officer and the other complainer.
Okay.
And then on the 21st of December, the investigating officer gave evidence at the commission to the effect that she couldn't recall the meeting referred to in JR 011. Disclosure of that material was damaging in a number of respects. First of all, it revealed, apparently revealed, direct contact between the investigating officer and the complainers immediately, or at least one of the complainers immediately before the formal complaint was made, and that altered the whole factual picture which government had when considering the question of not actual bias, because I don't think there's no suggestion of any actual bias here, but of whether the objective test for apparent bias was met. And government clearly had to review that question. And that picture of additional contact, one might say, called for explanation. Government was unable to explain that because the meeting couldn't be recalled. So government was not in a position to rebut what one might, the inferences that might be drawn. And there may be just a couple of, sorry, Ms. Baillie.
I know, it's just, I've got a lot of questions to run through, and
right.
I'm conscious.
I'm just trying to explain why the revelation of those documents was damaging.
I understand.
It's perhaps just worth making this point. It was obviously substantively damaging from the government's perspective, and properly prompted our review of the whole factual picture. It's also the reference to a meeting apparently to a meeting between the IO and one of the complainers on the day before the complaint was formalised, contradicted a statement the government had made in its pleadings. And the emergence of these documents at that very late stage also contradicted assurances which Council had given to the court and their counterparts about the disclosure of documents. So, you know, there was, as it were, an impact on the government's presentation of the case as a whole. But the critical point was that, as a result of all of that, a review was prompted to factor those additional facts into the whole factual picture, and the government concluded that it was no longer proper to defend the apparent bias allegation.
Can I take you back? Because the government opposed the Commission documents on December the 14th. Can I ask why they opposed the establishment of the Commission? Because that was where those documents were revealed.
Absolutely, and I should say that at that stage, government had gone through a process of voluntary disclosure of documents.
Yep. But at that stage, a senior civil servant actually told the court that there were no other documents to disclose.
Well, that's the point that I've just made, that the arrival of these documents, or the discovery of these documents in the course of the Commission process, contradicted assurances that had been given.
So if the government had won their position on the 14th of December, we would have never seen these documents. So I'm kind of left wondering whose interest was it to conceal it?
There was never any intention to or desire to conceal anything. In fact, from, as I said earlier, the whole approach the government took in November in terms of putting facts into the pleadings and disclosing documents voluntarily reflected a desire to be candid and transparent. Now, regrettably, and we know from the way that matters turned out, the investigations undertaken then into to identify all the relevant documents and to get a full picture of the facts was not as robust as it should have been, and lessons have to be learned from that.
I mean, I think you certainly said at your last appearance in the committee on the 8th of September to, I think it was Margaret Mitchell, that there was no decision to withhold documents, no. But why did the government then oppose the motion to establish the commission?
Well, I think I'd have to. I would have to give a. I may have to follow up.
Okay.
The reasons for that decision in writing, but what I can say is that it's an entirely routine part of the litigation process for a litigant to seek to oppose a formal order for the production of documents inter alia because it's already produced documents, or on a variety of other grounds. So that's not unusual for that to be a matter of
and I accept that. It's just
debate.
that the government didn't produce all the documents,
well,
clearly.
Well,
know? So can I move us on to, because it's clear from the timeline I have in my head and the evidence we've been given that actually the lack of independence of the investigating officer was known in late October, okay? Given that you're the government's top legal advisor, did you know about that at that stage?
I've already said it wouldn't be right for me to disclose my own involvement or non-involvement in the process. What I can say is that from late October, the government was well aware that that was an issue that required to be addressed.
Okay. Did you at any stage, probably can't answer this either, but let me try. Did you at any stage intervene in the process, particularly around the disclosure of information to the Commission on documents? Did you email, send memo? Did you pick up the phone to anybody to say, we need to disclose information?
What I can say is that the government was very clear, and this goes back to the initial point where the issue was identified and to the work being done in November, that it required to be candid and transparent. Now, as I say, it proactively put factual averments into the pleadings, it voluntarily disclosed documents. we know from what transpired in December that the process of investigation and identification of documents at that stage was not as robust as it should have been. Okay. And that is, there is no question that lessons have to be learned corporately by government in that regard. Okay. But at no point was there any intention, desire or wish to be anything other than entirely transparent, and ultimately for the government's decision to be determined by, laid before the court fully, as we do in all government litigation, and stand or fall by the decision of a court.
Okay. Can you, as our most senior law officer, confirm now that all documents, whether it's the Documents Commission, whether it's the search warrant in the criminal case, all documents have been released by the Scottish Government?
Well, I'm afraid, and I'm not trying to be at all difficult here, the phrase "all documents" and which documents are we referring to, and to whom are we considering?
If I knew that, directed. This committee would be over much quicker. I don't know that, which is why we're asking it of the Scottish Government.
Perhaps the point that can be made is that government carried out searches in November. It is clear those were not robust enough. Additional documents came to light in the course of the commission, which is not, frankly, and I've been involved in litigation for, nearly 3 decades now. It's not that unusual for documents to be identified in the course of a commission, but it shouldn't happen in a case of this sort, and it shouldn't happen where assurances have been given to others about the position. I think the committee is aware from evidence it's already heard that even after the commission, further documents were being identified. And again, that simply goes to illustrate that the process of seeking to identify all the relevant material in November was not as robust as it should have been.
Can I ask you, we're told that the Permanent Secretary took the decision to concede the case after a report from Sarah Davidson. Ms Davidson told us that she didn't, in fact, meet with any legal advisors. Did you ever see that report?
Again, I don't think it would be right for me to comment on what I've seen or not seen.
Okay. Let me try again in a slightly different way. So, according to the Ministerial Code, ministers may acknowledge that they've received legal advice on a particular topic, but not who provided it or the content. So, did the Permanent Secretary receive legal advice on the case at the time of the Davidson report? I'm not asking for the content. I'm not asking who gave it.
I think that's a question you'd have to ask the Permanent Secretary. My understanding is that the report itself contained legal analysis, and I think the committee's already had some evidence about the matters that were dealt with in the report, and it wouldn't be surprising if the Permanent Secretary sought additional legal advice thereafter. Okay.
So you're not aware whether the Permanent Secretary did or didn't seek legal advice?
I don't. As I say, I think it's a question would be better asked of the Permanent Secretary.
I know, but you're here.
Because, well, I'm very conscious I'm here, but in the sense that I'm not directly party to what she did and didn't do,
so
I'm not,
Let me ask you. Let me try in the same vein. Okay, in the same vein, did the Permanent Secretary or ministers receive written legal advice after the issue emerged in late October about the activities of the investigating officer?
There were, well, as I said earlier, advice is a process, and there was written advice, both internal and external, as I think I would be right in saying there were, of course, meetings at which advice may have been given verbally. It's not a, and in the normal course of things, that's all part of the way government comes to a decision about the position that it takes in a litigation.
So in response to Alison Johnson, you certainly gave me the impression that there was a review in December, but actually, based on what you've just told me, there was ongoing legal advice from late October to early December.
In any hard-fought litigation, there will be ongoing legal advice at different stages.
Okay. The names of the two external counsel are already in the public domain. I don't understand why we can't see their written opinions when Parliament has voted for it, and indeed the public paid for it. And you're unable to tell us whether you've had a request following the Parliament vote as to what was happening. So, just so that I understand, when Roddy Dunlop was giving his opinion to you, who did that go to? Was it to you? Was it to the Permanent Secretary? Was it to the First Minister? Was it channeled through you? What was the process of how that arrived?
Well, again, you're describing this as if there's a single piece of legal advice. In fact, advice is being given and received constantly in different ways, and you know, in the ordinary process of government, you know, that's. I don't think there's a sort of simple answer that could be given to that.
Well, let me put the question in a different way then. You know, at key points, Roddy Dunlop would have given his opinion. Usually these opinions from QCs are in writing. On the occasions where they were in writing, who did that opinion go to? Was it the Permanent Secretary? Was it the First Minister? Or was it filtered through you?
Again, I'm not sure that I can give an answer. I certainly can't give an answer here that would that I would be confident would be accurate in terms of what was done in every case.
Okay. It would certainly be the case that you could tell me in relation to yourself as Lord Advocate whether these opinions were filtered through you.
Well, as the committee knows, I'm constrained in terms of what I can say about my own involvement at different
which is why
stages.
I'm not asking about content or, you know, who gave it. I'm simply asking a process question about the flow of information. That's all I'm asking.
And again, I don't think I can give an answer that I would be confident would be accurate and appropriate, given the range of circumstances in which advice was being tendered and the different ways in which it was being proffered.
Okay.
How many more questions?
One more, Convener,
good.
you'll be pleased to hear.
Yes.
I rattle through my questions. According to the Ministerial Code at paragraph 2.3, it is your job as Lord Advocate to ensure that the government acts lawfully at all times. Clearly, this didn't happen in this case because the government's actions were described as unlawful, procedurally unfair and tainted by apparent bias. With the opportunity to look back, why do you believe that, as some have said to me, that you failed in this most important of tasks?
Well, I suppose the first, that it's quite important by way of general context. I mean, that's, you're absolutely right. That's one of my responsibilities under the Ministerial Code. Government's actions from time to time are tested in court. And from time to time, the judgments that have been made across government about their position, and the minister will, you know, any the member will appreciate law officers are at the apex of an enormous system of legal advice. You know, the Ministerial Code makes clear that most advice is tendered by others within the government legal directorate, albeit that